Okay, now let's start the second session. My name is TOSHINORI YAMADA, and the moderator in this session. I teach international law at the Meiji University in Japan, and I serve as a board member of IALANA and JALANA. This second session will consist of 3 parts: introduction, presentation, and Q&A. Now let's get to the introduction. In the first session, we heard from legal experts from Japan and Korea, focusing on lawsuits to bring relief and justice to hibakusha in their respective countries. We were also able to share the current situation of the damage caused by the US hydrogen bomb test in Marshall Islands through video testimonies. In this second session, we'd like to consider how kind of legal efforts are possible for the relief of victims affected by the use and testing of nuclear weapons and for the remediation of environmental damages. As you know, the Treaty on the Prohibition of Nuclear Weapons, TPNW, entered into force in 2021. The first meeting of the state parties is scheduled to be held in the summer of 2022, although the exact date has not yet been determined. The treaty includes articles on victim assistance and the environmental remediation, Articles 6 and 7. The implementation of these articles is also expected to be a topic of discussion at this meeting of the parties. In fact, Kiribati and Kazakhstan have issued a joint statement indicating that they will prepare a working paper on this topic. Experts and the civil society are also working on proposals on this topic. This session aims not only to provide an overview of the provision on victim assistance and the environmental remediation in the treaty, but also to gain relevant insights on this topic from the perspectives of international human rights law and the environmental law. Based on this, we hope to discuss with everyone what legal initiatives are possible and what are the challenges regarding victim assistance and environmental remediation. Today, we are pleased to welcome 3 speakers who are well suited for this purpose. First, we have Professor Manfred Mohr. He's a professor of Public International Law, Academy of Sciences, and a board member of IALANA. Professor Mohr will be speaking around Articles 6 and 7 of TPNW. Now, welcome, Manfred. The floor is yours.
Thank you very much, Gino. Thank you for inviting me to open the second part of this important event with an overview of Articles 6 and 7 of the TPNW. We can make use of this in relation to the items we discussed before. Just an explanation on my role. I'm board member of YALANA, that's quite clear, but I'm also co-chair of ICPU. To explain to you, ICPU stands for the International Coalition to Ban Uranium Weapons. So this is, so to speak, my second function. I'm presenting these slides here to you. Next, please. So first, I would like to explain that the TPNW is embedded somewhere. The ban treaty itself, the TPNW, was a result of a broad movement focusing on the catastrophic humanitarian consequences of the use of nuclear weapons. And this process was supported by YALANA, by ICANN, by other organizations. But it's important also to see that the TPNW is linked to general international law, like international humanitarian law, IHL, human rights law, and other more specific international law in this area, like the NPT Treaty, test ban treaties, agreements on nuclear weapon-free zones. And additionally, customary international law plays a role. Customary international law is just practice of states accepted to be law. And itself, the treaty, the TPNW, can be seen as an expression of customary law. In particular, so as this treaty is a lawmaking treaty, so has a special general role to play. And finally, as an introduction to the TPNW, I would like to refer, as others did before in the first part, to the advisory opinion of the International Court of Justice in 1996, stating that the use or threat of use of nuclear weapons would generally be contrary to the rules of international law applicable in armed conflict. So this is a fundamental declaration and statement delivered by the court, and there are no exceptions. There's not really a loophole as it's discussed in theory, but I think there's no loophole. The fundamental statement is what counts. Next, please. These are some pictures to illustrate in a way effects of the war on the environment. The scene of Hiroshima after the atomic bomb explosion in August 1945, and on the other picture you see oil fields set on fire by Iraqi military forces in Kuwait. Next. Environment and war, what does it mean? There's a general and refreshed international discourse going on, which is also in conjunction with the issue of environmental protection as such, and also with the climate change issue discussed. So this is a missing link between climate change activists like Fridays for Future and peace activists, what we are doing here now. Now, the International Law Commission of the United Nations has drafted principles on the protection of the environment in relation to armed conflict, so-called PERAC. And also Harvard Law School and the Conflict and Environment Observatory, CEOPS, has drafted, formulated principles for assisting victims of toxic remnants of war. For many years now, November the 6th is the UN Day against environmental destruction by war. These are all very important developments and substances we have for our discussion. And to make it clear in the end, in presenting this fundamental topic, our aim is not to green the war, but our aim is and still remains outlawing the war altogether. Next, please. You see now a picture in relation to the victim perspective, which is very important. This picture, next please, is taken from the World Nuclear Victims Forums held in Hiroshima in 2015. This forum adopted a declaration also with references to the Shimoda case already discussed here and the ICJ advisory opinion. The declaration contains draft elements on a World Charter of Rights of Nuclear Victims. These rights range up to compensation. Now what we have here is the concept of humanitarian disarmament, which means to have a victim-centered approach and to follow a course which is aimed at pragmatic solutions, solutions in favor of the victims, and not so much directed at ideal solution, complete disarmament, structures, etc. This is humanitarian disarmament. And also linked to the concept is that protection, the rights of the most vulnerable have to be highlighted, are even more important, like rights and the situation of children, of women, and the rights of indigenous peoples. And these rights, the rights of the victims affected, remain important, even like, for instance, uranium weapons, depleted uranium weapons might disappear, or in decades to come, even nuclear weapons may disappear, but the victims of using these weapons are still there. Next, please. What I'm proposing to you here is to follow a multifaceted legal approach. That is, victim and environmental protection can be based on 4 main legal branches of law. The first, which is disarmament law, like the TPNW. The second branch would be IHL. Here we can refer to the principle of distinction, the rules on civilian environmental protection, which are linked. And then we have human rights law. Daniel will take up this matter later on, as environmental law will be discussed and presented by EMILIE also after the next speeches. In addition to this, we have legal principles, general principles, that is the precautionary principle, for instance, that are important. The precautionary principle you may find in environmental law and in IHL as well, just says if you are not sure about damages being caused by an activity or a substance, take precautions to avoid these damages. There's something risky and you better stop risky actions. And there are other general principles like proportionality principle that are important. All these principles and branches of law can be applied in parallel. Normally you have the lex specialis rule, which says the special law is more important, but here you have many branches and principles effective side. So finally, it is a complex picture and we need expertise and exchange in this regard between various experts. Next, please. Victim assistance and environmental mediation under Article 6 of the TPNW. This article has been referred to already several times, so it's just quoted here, and you can have a look at it later on, or you did already. So this is a core article of the TPNW, Article 6. Next, please. What is important here? This article contains positive obligations that have practical effects for victims. And the assistance mentioned in this article is age and gender sensitive. Psychological support is even mentioned. And also, quite relevant, is the aim of social and economic inclusion. Altogether in this article, we proceed from the real needs and the rights of victims. So financial compensation would not have, in the end, it is important, but it's not alone the solution. And also in view of possible controversies about causal link between damages and the situation of victims and the use of weapons, we would suggest the application of the presumption of causation rule. So to operate with assumed illnesses and that avoid the necessity of proving the causal link altogether. Next, please. Also, another principle you can find in the TPNW is that on shared responsibility. So the main responsibility rests with the territory or the affected state, which is in the best position to help victims. So if you look at the affected states, like the Marshall Islands, for instance, they can offer help, they can organize help, and that can be done even without the nuclear weapon states joining the TPNW. And Article 6, paragraph 3 also refers to obligations of other states under international law in this conflict. So again, the TPNW is embedded in international law, and bilateral agreements like the US Marshall Islands Agreement may count. And very important, we have paragraph 6 of Article 7 saying that there's a special responsibility of nuclear weapon user states. And again, this responsibility exists also on the basis of other obligations under existing international law. This formula of paragraph 6, Article 7 is a unique formula we haven't found before in international treaty law, and it's of a clear legal and not only a moral nature. Next, please. So in Article 7, cooperation is mentioned. In line with the general international law principle on international cooperation, these cooperation schemes are especially relevant in the context of nuclear weapons, in the context of environmental destruction and help for victims, because the affected states, like the small island states in the Pacific, are alone not often able to cope with the challenges, with the demands. It is also very typical for humanitarian disarmament law that in this article mention is made of the right to seek and to receive assistance by states that are in a position to do so. And also, finally, reference is made to organized assistance, institutions like the United Nations and the Red Cross. Next, please. So we come to implementation. Implementation is always the crucial issue for law altogether, be it domestic law, international law. These laws and rules have to reach out to victims, so they have to be implemented. And here, as we saw in the first part of our webinar, domestic law, the national sphere is most important. And we have judicial experience. Maybe we can still have a discussion on this in the final phase of our webinar. So Article 5 of the TPNW speaks about national implementation. It is very openly formulated and have to be filled out at the first meeting of states parties of the TPNW, and we try to arrive at a fully fledged implementation system, including national action plans, supervisory procedures like reporting, etc. And part of this consultation process will be the discussion of this scheme, and the consultation process already has been mentioned here, which is led by Kazakhstan and Kiribati with inputs from our side. Next. So you see here an electronic formula for human rights complaints, informal complaints. Next, please. And these electronic files are available under the Office of the High Commissioner of Human Rights and Special Rapporteurs of the Human Rights Council. This formula, these files have been used to help cases of uranium weapons victims in southern Serbia. And these schemes, these files are an alternative to court proceedings. Court proceedings, as we also learned before, are quite often very complicated, they are costly, and this is a more easy way to go ahead with the rights of victims. Now we come also to the very complex issue of strategic litigation, which simply means, is it necessary, it is worth to go to courts, which is a very fundamental issue also for YALANA and EMILIE. And as a footnote, the Marshall Islands case has been mentioned before, victims have been shown, and there was even a fact-finding mission of a special rapporteur on toxics. And on the other hand, there was an ICJ case on Marshall Island, which was dismissed in 2016. Next and final, please, conclusion and outlook. You see some pictures about activities by ICANN, other organizations. Next, please. So my conclusion would be, make use of the great potential of the TPNW, especially Articles 6 and 7 in relation to victim assistance and environment remediation, but also in the context, do this in the context of already existing international law. And then it would be necessary, as we do now right here with the webinar, to start and further exchange the views and experience among lawyers of different branches of law on related issues. Then it would be advisable and necessary to work on the input of YALANA into the international discourse against the broader background of environment and conflict, in particular in relation to ongoing and future consultation activities, like the one in relation to the first meeting of states parties of the TPNW. and I see also a need to continue the discussion and joint endeavors among civil society factors such as IALANA and ICANN, where sometimes there are some misunderstandings, different views, but exchange and dialogue is needed also here. And to the very end, and finally, don't neglect the role of media and art in this connection. And also media are aware of the relation between environment and war. And I got an interview request by the media in contact with the Ukrainian war just going on, this catastrophic war just in face of us. And media are just eager to get information about the situation there in this world. So environment and law, environment and war is seen as a general topic. Thank you very much for your attention.
Thank you. Thank you so much, Manfred. Thank you for your clear presentation that captured the big picture. Now, next speaker. The next speaker is Dr. Daniel Rietiker. He's adjunct professor at Lausanne University and Suffolk University Law School. And he is our co-president of IALANA. Daniel will talk about how nuclear disarmament can be approached from the perspective of international human rights law. Welcome, Daniel. You have the floor.
Thank you so much, TOSHINORI, for giving me the floor. Okay, again, thank you very much, dear TOSHINORI, dear members of JALANA and IALANA, for giving me the floor. Dear colleagues and friends, I'm very happy to speak to you on this important topic, and indeed, thank you very much to JALANA for organizing such an important event on such a timely and an important topic. I'm very glad as a co-president of IALANA to have JALANA as probably the most active branch, national branch of IALANA. I'm very happy to cooperate with you. So I was asked today to speak about the topic of how to bring human rights into play in order to pursue our topic of nuclear disarmament. This is something which I have been researching for quite a long time, and you might also know, be aware that several organizations, Basel Peace Office, Swiss Lawyers for Nuclear Disarmament, LCNP, we have already submitted to human rights bodies, in particular the Human Rights Committee, the UN Human Rights Committee, petitions or submissions on human rights violations in the context of nuclear weapons. And this in particular based on the General Comment 36 on the right to life of the Human Rights Committee. This is a very important document where myself and certain colleagues have been involved in its establishment. So our submissions, recent submissions on several states have often been around, shaped around this General Comment number 36 on the right to life. But I think now it's time that we enlarge our point of view a little bit and don't stick only on the right to life. And that's why today I do not speak about the right to life or General Comment number 36, like I have done this quite on many occasions, but I want to talk about something a bit new, means economic, social and cultural rights. From my point of view, there are treaties, international treaties, which might be relevant, and bodies which deal with these treaties, which might be relevant to be addressed for our purposes. Just I have prepared too many slides, so I'm jumping on certain of them, and I told this the translator. I wanted to talk a lot about the advantages of human rights law, but you find information in my book published on that. Only one aspect here on this slide. I think it's very important. The institutional dimension is very important. Means that in human rights law, in the field of human rights, there are quite a lot of institution, UN bodies, but also regional institution, European Court of Human Rights, etc., which can be addressed, contrary to international humanitarian law, for instance, where it is often the states who implement these treaties. Also, contrary to arms control treaties, which are not so far before the TPNW dealing with human rights law. This might change now, but NPT is not a human rights treaty. On the next, a second point which I wanted to raise on the added value of human rights law is that one, the particularly vulnerable groups. So human rights law, as Manfred already said, often focuses on particularly vulnerable groups. We can see this in the TPNW as well, and I will talk in the end a bit about children's rights, just to introduce this topic as well. So many advantages which can be used by our communities to bring nuclear disarmament into human rights bodies. I will skip those. This is the right to life, which I'm not going to talk about today. I want to talk a bit more about economic, social, and cultural rights today. So in my book, I wrote about the impact, and this is quite recent research coming up and establishing that the serious impact of a limited regional nuclear war on global development, health, environment. Studies have been conducted on exchange of nuclear weapons, a couple of nuclear weapons between Pakistan and India, coming to the conclusions that this would be a heavy drop in temperature worldwide, and also in a drop of agricultural production worldwide, which will bring around crisis and hunger, poverty, and I think development issues. And I think it's exactly there where economic, social, and cultural rights can play a certain role. So really something which affects us globally, a nuclear weapon exchange between two countries, only a couple of nuclear weapons would globally affect our economic, social, and cultural rights. Then the three types of duties under economic, social, and cultural rights. This is not very important for today. Respect, protect, and fulfill. This is like the trilogy often in human rights law. But let's go into the two economic, social, and cultural rights, which I find important. The first one is the right to health, the right to a higher standard of health, or just briefly, the right to health. We have a legal basis on that, Article 12 of the International Covenant on Economic, Social, Cultural Rights, which says that the states parties to the present covenant recognize the right of everyone to the enjoyment of the highest standard of physical and mental health. So this is a treaty which has been ratified by many states. In general, comment number 14 on the right to the highest standards of health on this human rights. The Committee for Economic, Social, and Cultural Rights is a bit like the Human Rights Committee, but the committee implementing that treaty said that states should refrain from all unlawfully polluting air, water, and soil, for instance, from using or testing nuclear weapons, if such testing results in the release of substances harmful to human rights. So here we have also in that treaty, or in a text related to that treaty, we have a clear reference to nuclear testing. So it's already something we can work on, I think. So this paragraph underlines the negative impact that nuclear testing or nuclear accidents, I would say, or the use of nuclear weapons might have on the enjoyment of the right to health. In 2011, in a report of 2011, the German Affiliate of International Physicians for the Prevention of Nuclear War, IPPNW, and other organizations summarized the tragic consequences of the Chernobyl accident on the Ukrainian population as follows. I'm talking about the right to health. So even though I'm quoting here, even though the lack of large-scale independent long-term studies does not permit a complete picture to be made of the current situation, a number of trends can be shown. A high mortality rate and the almost 100% morbidity rate can be observed among people such as liquidators who were exposed to high radiation levels. 25 years after reactor catastrophe, cancer and other diseases have emerged on a scale that, owing to the long latency period, might have appeared inconceivable immediately following the catastrophe. End of quote. I think that, however, to reduce the impact of nuclear tragedy on people to mere cancer statistics would be too narrow and not responsive to the human suffering, in particular the psychological endured by the affected population. It is relevant for the present study to highlight that the Special Rapporteur on the right of everyone to the enjoyment of the highest attainable standard of physical and mental health, Anand Grover, visited Japan in November 2012 in order to ascertain the country's efforts to implement the right to health in the aftermath of the Fukushima nuclear accident of March 2011. In his report, he stated that the nuclear accident in Fukushima has affected the right to health of evacuees and residents alike, and has had an impact on physical as well as mental health, particularly of pregnant women, elderly persons, and children. He added that the evacuation had caused a breakdown of families and communities and had given rise to mental health concerns. So I think this is just one episode showing clearly the relevance of the right to health for our work. A second human rights, economic, social, and cultural rights would be the right to an adequate standard of living, including the rights to food and water. Here we have Article 11 of the same treaty of the International Covenant on Economic, Social, and Cultural Rights, which says that state parties to the present covenant recognize the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. The state parties will take appropriate steps to ensure the realization of this right. And here again, I think we have at least two interesting aspects: the right to food and the right to water. So as far as the right to food is concerned, as an aspect of the right to an adequate standard of living, the Committee on Economic, Social, and Cultural Rights, again the same committee, which could be addressed by us sooner or later, devoted its general comment number 12 of 1999 to the right to adequate food, in which it recognized that this right is of crucial importance for the enjoyment of all rights. This plays obviously a significant role in a scenario of a detonation of nuclear weapons. Indeed, such a detonation would have a particularly harmful impact on the environment, and the effects of radiation on the human being would be exacerbated by a nearly irreversible contamination leading to the loss of livelihood and lands. According to UNDP and UNICEF, the radioactive fallout from Chernobyl disaster contaminated large areas of Ukraine, Belarus, and Russia, affecting life in the rural communities for decades to come, and having led to prohibition of agriculture and forestry in wide areas. Another aspect of the right of an adequate standard of living would be the right to water. In its general comment number 15 on the right to water, the Committee on Economic, Social, and Cultural Rights noted that the right to water, even if not mentioned explicitly in Article 11, falls in the ambit, in particular because water constitutes one of the most fundamental elements of human survival. Many paragraphs, I would say, from this general comment are relevant, but especially the following one. So regarding water contamination by nuclear weapons, general comment number 15 states explicitly that the obligation to respect the rights to water includes the prohibition of diminishing and polluting water, for example, through the use and testing of weapons. In a nuclear explosion, radioactivity penetrates the atmosphere, soil, and water. In the desert of Nevada, where clean water is already scarce, US underground nuclear testing conducted between 51 and 92 is estimated to have contaminated more than 6 trillion liters of groundwater. Adequate access to safe food and potable water was also a problem on the Marshall Islands, which were the place of numerous nuclear weapons tests, as we have heard before.
Excuse me, Daniel. Could you be wrapping up now?
Yes, I will wrap now. I will be short on the children's rights. Okay, no, I can stop here. I can stop here, and we can always come back on that. Maybe a couple of conclusions. Two sentences, final conclusions. So I have 2 pages of conclusions. I think the most important here on the second slides, where I say that economic, social, and cultural rights have so far been neglected in our circles, and they should be used in future to address our things, our purposes, our aims. And I think it's again important to focus on particularly vulnerable groups such as children, women, and indigenous peoples. Thank you so much for giving me the floor.
Thank you, Daniel, and thank you so much to keep time, and thank you for the very great insight into the importance and the potential of the articles of various human rights treaties and the view of human rights bodies. The next speaker and the last one is Madame EMILIE GAILLARD, a lecturer in private law as SciencesPo Rennes and a board member of IALANA. She will talk about issues related to this topic from the perspective of environmental law, probably including the rights of future generations. Welcome, Emily. The floor is yours.
Thank you so much. I'm very pleased to see you all, to meet you, and to have a 10 minutes presentation with you. So my presentation will highlight the question of nuclear through the lenses of rights of future generations. So just to let you know that now I'm the general coordinator of the Normandy Chair for Peace, which is dedicated to peace with the earth and the recognition of rights for future generations. I would like to emphasize on the fact that in the topic, when we talk about framework of environmental remediation, I would like to emphasize on the fact that this is a way of analyzing the reality of nuclear damages through old beliefs. There is no reality of remediation when you have a nuclear disaster, when you have nuclear victims. Why? Because we enter in a new era with transgenerational damages, with genetic damages caused to all forms of livings, non-human livings, human livings. And we can see when we talk about the past that we have the burden to make the truth and the reality on this transgenerational reality be denounced and people to be informed of that and trained of that. The idea of remediation, environmental remediation, once you have a nuclear disaster, is a nonsense because we have to change of paradigm. It's the same beliefs that we have with, the very concept in economics of growth. We have imagined a world and a world economy on the very concept of growth, but the infinite growth in a world of finite resources is impossible in reality. It is the same for environmental remediation. We cannot think about remediation in a world which is contaminated by nuclear by radionuclides. So let me emphasize on that point and on the very need to recognize rights for future generations, and why is it a change of paradigm. So it's a revolution in ethics and laws, because in the ancient world, there was no need to imagine a law for the future, because naturally the future will look after himself. There was no need to think about rights of future generations. And of course, it was obvious that laws was built ignoring the future. So this is a Copernican revolution that we have to integrate in our laws, in our ethics, tension for future generations, rights and duties for future generations. So it's a disclosure of our way of thinking in law about things that are, or issues that are happening now, but as long as they will have long-run effects, we have to integrate the very concept of future generations in law and create a law for future generations. So this is what we call a change of scientific epoch, a revolution. So you have already many authors who have paved the way on this necessity to get open-minded to another way of thinking. The nuclear threats has a specificity because humankind has acquired an unprecedented power on the earth, on the conditions of the livings, not only on the humans. I said it already. All living forms on this earth can be contaminated by nuclear radionuclides, and also those to come. So this is a tremendous metamorphosis in ethics. So for some, it's the entry into the technological age, and the one I want to emphasize on is Günther Anders. He said that the nuclear technology introduces a disruption in the history of humankind, because now humankind has the potentiality to introduce a disruption in the very concept of history. To explain it in other words, usually we think that there is a tension which is natural to go to the future. But when we think about nuclear disaster, nuclear bombs, nuclear contamination, nuclear minings, we are facing temporal, transgenerational contamination, transspecies and transspatial. So these are totally out of the box. And what I like in Günther Anders' way of thinking is that he emphasizes on the fact that the nuclear technology, the technology by itself, prevails on human morality. That means that we do not have the ability, our psychological cognition capacities are too limited, or even the way we are trained, formed, and the way we're thinking. It's not natural for Occidental people to think about the consequences as in the long run, and even more, for instance, for the nuclear waste, is 5 billion years of pollutions. And this changes the very foundation of our moral existence. And there is a Promethean gap between what we can do and what we are able to imagine. And the fact that we are still thinking about new framework about environmental sanitation framework or remediation means that we are still not thinking about the reality that we are facing disasters, and these disasters are eternal if we think about human rights scales, and also that for Fukushima, it is an ongoing disaster. I would like to quote a French philosopher who is one of the more important philosopher on catastrophism. He said that catastrophes are characterized by this temporality that is in some sense inverted, as an event bursting forth out of nothing. The catastrophe becomes possible only by possibilizing itself. And that is precisely the source of our problem. For if one is to prevent a catastrophe, one needs to believe it in its possibility before it occurs. And if, on the other hand, one succeeds in preventing it, its non-realization maintains it in the realm of the impossible. And as a result, the prevention efforts will appear useless in retrospect. This is the key. First key, if you want to prevent nuclear disaster, you have to think and accept that it is a possibility. For instance, the actuality is now that people in Europe who forgot totally the reality of the nuclear disaster or nuclear threats are facing it for the first time. Our youth, our students, when I was teaching that to them, they were thinking and they were absolutely convinced that it was a threat from another age. But so we have to educate people about this possibility of nuclear disaster, which is the same also for nuclear power plants, for accidents also. So we have to believe in its possibility in order to prevent. So the reality is that we have to recognize fundamental duties towards future generations, rights for future generations, and for all other species. That means that now we have to prevent nuclear disaster. So the difficulty that Jean-Pierre Dupuis explained, and which is the latest paragraph, is that if you do correctly your work of prevention, then people may not realize that you have really prevented from this disaster. So now the problem that we have is that we have created unprecedented pollution all around the world with nuclear tests. So I don't know if you know, but maybe you know it, and maybe we have been informed by JALANA. This map, this interactive map created by a Japanese artist on the nuclear test, it's a 15 minutes movie, which I show to my students every year. And that makes you realize that we have already entered in this transgenerational era of contamination. And what I do, and what I'm expert to do, so this is a book that we have published, maybe I will share my screen first, is to think for transgenerational human rights and to propose legal actions for future generations. And these legal actions for future generations can also take advantage on this new way of highlighting human rights. For instance, what I was explaining already a few years ago on this capacity, on this possibility to highlight every human rights in tension, in relation to future generations, is now occurring. Last year, on April 2021, the Federal Constitutional Court of Germany recognized fundamental rights and duties towards future generations. The right to life can be highlighted, no more like the right not to be threatened by death penalty, but also the right to be born in a healthy, non-contaminated earth. So this debate, which was yesterday more like prospective, like theoretical, is now entering lawsuits and entering the courts, and we are not now facing this. So these are some thoughts I wanted to share with you, and maybe I shorten my presentation because I see that there is a lot of message, so I want to respect the time of presentation.
Okay, thank you. Thank you very much. Very thought-provoking and implicating presentation. implicating. Thank you. Now we will move on to the Q&A session. We are running out of time, but please allow us a few more extensions. Before I introduce questions from the floor, I, the moderator, would like to first pose a common question to the three speakers. That is, what are the specific ways in which Articles 6 and 7 of the TPNW can be used to help victims of the use of nuclear weapons or nuclear testing, or to advance environmental remediation? In other words, to that end, what proposals can we effectively make at the first meeting of the parties to the TPNW?
Okay, thank you, Toshinori. Can you hear me? Is it okay?
Okay.
You got me? Okay. So I want to make just four brief points. First, we have to stress the practical relevance of these two articles in the TPNW. As we are discussing the role of the Ban Treaty, nuclear weapon states may never join. Is it really important for lawyers, for peace activists? We would say and stress, yes, it is, just because of Articles 6 and 7. They are there. They are there for helping victims, and they have the schemes for helping victims. I agree with Emily that environmental remediation is nearly impossible after atomic bombs being thrown, but still it is an issue. And in the case of testing nuclear weapons only, there may be some remediation available. So it is at least an issue, and it's also in the two articles. Secondly, as I stressed in my presentation, these TPNW rules, articles, and the treaty itself is embedded in existing international law. So again, maybe the TPNW will never be legally binding upon nuclear weapon states. Nevertheless, the substance of the treaty is binding upon them through other branches of law, through customary international law. So the TPNW counts to be optimistic in a way to propagate the treaty. And Daniel made the point on social economic rights, which is really very much, this is very important and has practical relevance. But I would also like to stress the role of the right to information and to remedy. And we heard in the first part of the webinar that information rights are so important, and remedy rights. And here I want to make a practical proposal for IALANA and JALANA. Let's work on a standard argumentation against nuclear weapon states using nuclear weapons or testing nuclear weapons, standard legal arguments we have from international law as such, human rights law, so to make a working tool out of it, a working paper that domestic lawyers could use, the lawyers we had in the first part. So it could be used with constitutional law, civil law arguments, and linked together. So to have a step further. The third brief point is that we have to develop implementation systems, as I mentioned before. And Daniel referred, and also Alan in the chat, about using international implementation schemes, but also, as I said, to make use of informal schemes. So every nuclear victim can go to the United Nations human rights system, just filling in an electronic file and send it off. So that would be a third issue, very important, implementation. And finally, the principle of shared responsibility. I touched upon this earlier, not to leave non-nuclear weapon states alone being parties to the treaty and working on it, but to see the remaining responsibility of user states. And here I may just briefly answer the question raised by Caroline in this exchange room. What about special funds then? Yes, I would say they count. And Emily, I think you know about super funds and special funds that are very important in the environmental field. So as non-legal funds, just to get money together in special fund systems through development states and other states organizations to have money available to help victims, regardless of legal obligations, but just to do some practical work and practical implementation activities. Something to be added. Thank you.
Thank you, Manfred. Okay, the next. How about Daniel?
I feel like a student at an oral exam at university. TOSHINORI. I have not prepared for this, but still, I have some thoughts because I have been working especially with Manfred on that issue, and we have submitted a paper on to the Kazakh diplomats who are preparing this working group in hopefully in summer. Difficult question, and I am very curious to see what is going to happen with this Article 6 and 7. I think first we have to see the standpoint of this new mechanism. Will it be like a complementary thing? Will it like complement the normal human rights bodies, or is it going to be something specialized, saying that all the human rights bodies, Human Rights Committee or a Committee on Economic, Social and Cultural Rights, are going to send possible complaints to the new organ created by the TPNW, or is it the opposite? Can all the victims send something to the new organ within this arms control treaty, which are going to be sent to the normal human rights treaty? So I think this is really important. We have to decide: do we create a new organ, a new mechanism, or are you going just to help the victims to address the right bodies? I think this will be very important, and it can really change the whole UN human rights system as far as nuclear weapons victims are concerned. So I'm really curious to see. I don't think that we are going to create a new human rights organ who is capable and has jurisdiction to receive complaints. I mean, we are not human rights lawyers. I mean, some of us are, but mostly we are talking about specialists in arms control. So it's a really important question. Is it complementary? Is it subsidiarity or what? And then a second point, I think whatever will be the mechanism, I think the vulnerable groups issue is very important. But there again, we have the CEDAW, we have a treaty on the elimination of discrimination against women. We have Children's Rights Committee, very active on Fukushima victims, for instance, right to information. So I don't know if we have to reinvent the wheel. You see, also on these vulnerable groups, I think they are bodies which are very specialized already, which work well. So I don't know. I think very important the cooperation between these bodies. And then also I'm puzzled also about, or I'm curious to see, what is this going to be? Is it rather to be a mechanism for future victims? Are we going to work on prevention of future accidents? Or are we taking on board all the victims of nuclear testing and nuclear use of nuclear weapons? In the treaty, it's clearly said past and present and future victims of nuclear weapons. But it's very important, I think, to decide where will be the focus. This is the second point I wanted to raise, or the third point. And yes, I think very important will also be the responsibility of states which under Article 7, which have never had nuclear testing on their territories, but who have tested. So the nuclear weapon states, of course, we have to find solutions how to bring them on board, how to make them pay their share, basically. So it's all, I mean, the Marshall Islands or Kazakhstan are the main, among the main places where nuclear testing has been taken place. These are not necessarily the states which are probably from a financial point of view, the states who will be able to pay the victims. So I think it's important that we take on board the states who are responsible for testing and using nuclear weapons in this Article 7. And Article 7 is quite binding. They say that states shall contribute to this view. Okay, maybe not 5 minutes, but
Okay, thank you, Daniel. And last and not least, Madam Emily, how about you?
Yeah, thank you, Toshinori. Several things. We have to integrate complex thoughts, so we have to integrate past, present, and future in the way of thinking the implementation of this treaty. Concerning Articles 6 and 7, I think that there is a range of action that can be done. First of all is the mapping the reality of all the nuclear tests, such as in the map that Aline shared the link in the chat. Mapping, transmitting the information, because we have a right to an access to environmental information, but in the long run, you know, this information may be forgotten. All the nuclear tests, the nuclear accidents, power plants, minings, etc. We have a lot of problem in France. For instance, just an example, in France, there is not much done about the nuclear test in Algeria. Now it's a sovereign country, but the nuclear test has polluted the environment. In French Polynesia, it is also something which is beginning to be talked about. There has been agreement with the Prime Minister cabinet a few years ago. So I went in French Polynesia and I proposed kind of truth and reconciliation committees. So you can map, you can provoke a collective work of resilience through truth and reconciliation committees. We can do that for countries or at larger scales also, because this information needs also to be followed in the long run. As you know, we're talking about transgenerational threats. We have now some attorneys in Russia who are defending grandchildren of liquidators of Chernobyl. We are thinking about out of the box that now we can have problems of children today, of our future children, that are linked to this nuclear pollution and nuclear weapons also. There is also a work, I think, about when we talk about international cooperation and assistance. Again, there is a belief which is really strong that nuclear is something that we have to rule with a new treaty. But if you highlight the international principle of non-harmful use of the territory within a state jurisdiction. Do you understand what I'm saying? Because in French, it is utilisation non dommageable du territoire national. Daniel, tu peux m'aider à traduire en anglais, s'il te plaît? Le principe d'utilisation non dommageable du territoire national.
I think it's quite clear. It's just a trail smelter case, isn't it? It's just that you cannot harm territory outside from your own territory. It's a very simple rule.
Okay, so I did the correct translation. Yeah. So this principle of international public law is already a principle of positive international public law. And I think that we can also already denounce that nuclear technologies is already a technology which infringes this principle of international law. So the thing that I can propose to JALANA and YALANA with the Normandy Chair for Peace is to strengthen this approach of consequences in the long run. And I didn't finish my presentation because I didn't want to be too long, but I would like to add two more precision. What I'm specialized in is to take any generation of human rights and to explain that it is a new infringement for future generations. For instance, the freedom to come and go in Fukushima, it is no more possible. The right to health with endocrine disruptors or nuclear energy pollutions is also an infringement of rights of future generations. So this is a metamorphosis It has been think by Commandant Cousteau in 1993 at the University of Laguna. And now this proposal of recognizing human rights for future generations is in new declarations, in new consultative advisory opinion in front of the Inter-American Court of Human Rights and other human rights regional courts, and also in other courts. So this is something which is more and more of topical issue in many, many scales throughout the world. I hope that I was clear enough with my English today. Thank you for your attention.
Thank you. Thank you, Emilie. Okay. Now I'd like to open the floor, but we have one question in the Q&A box. It's about Germany, and this question from Germany. Oh, I think it's good for Manfred to reply to this question. Can you see this question in the Q&A box, Manfred?
Yes, TOSHINORI, I can see it. I already tried to answer. Maybe I was too short. It's by Caroline Fail. Whether we can just recommend setting up a compensation fund just organized by the TPNW member states, and I would say yes, it makes sense very much. As I mentioned earlier, the idea of compensation funds, so-called special funds, is very widespread in environmental law issues, environmental damages. All the damages caused in the United States, for instance, in relation to 9/11 and other catastrophes you have at the Gulf of Mexico, they were all settled by special compensation funds. And these funds work relatively independent from the legal settings. So just firms, states, NGOs, they get money into the funds, they pay for it, just to try to help victims and to regulate the environmental issues that are relatively complicated in connection with nuclear weapons, as I admitted. So I would say, yes, it would be a chance to go ahead with victim assistance. This is an answer to the question by Caroline or Carolina. And thanks for the question, a very practical one.
Thank you. Thank you, Manfred. Now, we are now running out of time. I'd like to conclude this second session. In this session, many ideas about victim assistance and environmental remediation were brought up, and the challenges were identified. So I hope that we can continue to share these contents with all of you and connect them to more effort to victim assistance and environmental remediation. Finally, I would like to thank all the speakers of the second sessions for their excellent presentations and answers, and enthusiastic discussions from the floor. Thank you. Thank you so much.
I would like to give a concluding remarks. How was today's webinar? So in the first session, we heard from Japanese and Korean lawyers and focusing on litigation to bring relief and justice to hibakusha in their respective countries. And we were also able to share the status of the damage caused by the US bomb test in the Marshall Islands through the video testimonies. Although the theme of the session was to look back at the past, it's clear that nuclear damage is by no means a thing of the past. Hibakusha from Hiroshima and Nagasaki are still alive, not only in Japan, but also in Korea and DPRK. The victims of the beginning nuclear tests are still filing lawsuits against the Japanese government in Japan seeking redress. What we reviewed in the first session was the efforts made through lawsuits filed in the past, but the damage that needs to be remedied is still ongoing. There are victims of nuclear tests all over the world. The scope of these victims has not yet been determined. The issue of second and third generation victims of radiation exposure is a clear indication of this. So it must be recalled that the relief for these victims is also not adequate in the present situation. In the second session, we were talking about what we could do utilizing Article 6 and 7 of the TPNW. The challenge is how to operationalize this mechanism in the future. So if this is well operated, it may lead to relief not only for victims of the TPNW parties, but also for hibaksha around the world. And it's important to note that there are norms and procedures in existing human rights law and environmental law that facilitate victims' assistance and environmental restoration. These are already functioning apart from TPNW. So one of the issues to be discussed in the upcoming meetings of the state of the parties on the TPNW will be how to establish mechanism. So Kiribati and Kazakhstan have already started that they are preparing a working paper to that end. So it will be necessary to originally link the TPNW mechanism with those in human rights law and environmental law. Through such a device, the norms contained in the TPNW may be able to substantially affect non-parties outside the TPNW. This is an important issue, given that countries with large numbers of hibaksha, such as Japan, Korea, DPRK, United States, and China, will not be participating in the TPNW in the foreseeable future. Hibaksha around the world are paying close attention to this meeting. I hope that the discussion in this webinar has contributed in some way to the future efforts of those of you attending today. If you have any further questions or would like to share information about today's content, please do not hesitate to visit the IALANA or JALANA websites. Finally, I would like to thank all the speakers for this webinar and the audience for their participation. I would also like to thank the interpreters for their long hours of work. Thank you very much. So that concludes today's webinar. Thank you very much.